Good morning, sir. This is oral liberation for CLG 6 Criminal Procedure. Rule 110 Prosecution of Offenses. Section 1 Institution of Criminal Actions. These sections state that any offenses outside in Metro Manila that has more than 6 years and 1 day punishment should require a preliminary investigation. Well, if the offenses punishment is less than 6 years and 1 day, the complaint or permission should directly file with the municipal trial court or municipal circuit trial court and office of the prosecutor. For the offenses in Metro Manila and other charactered cities, the complaint or information should be filed office of the prosecutor. Section 2 Rule of 110 state that the general requirements of the complaint information are first shall be in writing, second in the name of the people of the Philippines, and third against all persons who appear to be responsible for the offense involved. Section 3 and 4 of this rule define the complaint and information, which is complaint is a sworn written statement charging a person with an offense subscribed by the OPP or the offended party peace officer or other public officer charged with the enforcement of the law violated and filed in the prosecutor office. According to Section 5, Rule of 110, public prosecutor shall prosecute the criminal actions. That is the general rule, but it has exemption where a private prosecutor can be prosecute the criminal action when in a case of heavy work of the public prosecutor or in the event of lack of public prosecutor, but even though the circumstances are prosecute, private prosecutor can prosecute the criminal action unless he and she has written authorization by the Chief Prosecution Office and should have the approval of the court. The second paragraph of this section states that the private crimes, adultery, and concubinage shall be prosecuted only if the offended spouse will fill the complaint or information. In Section 6 to Section 12 of the Rule 110 state the sufficiency of a complaint or information. The general rule of the duplicity of the offense on Section 13 of this rule is that in one information is equal to one offense. Exemption is when the law prescribes a single punishment for various offenses. Rule 111 Execution of Civil Action. According to the Section 1 of this rule, when criminal action is instituted, the civil liability shall be deemed instituted. That is the general rule, but there is an exemption. First, when the offended party waives the civil action. Second, the offended party reserves the right to institute separately. Rule 112, the preliminary investigation. According to Section 1 of this rule, preliminary investigation is an inquiry of proceeding to determine whether there is a probable cause that the crime has been committed, and the preliminary investigation is required to be conducted before filing a complaint or information for an offense where the penalty prescribed by the law is at least 6 years and 1 day imprisonment. The officers allowed to the conduct preliminary investigation are provincial or city prosecutors. Under assistance, national and regional state prosecutors and other officers as may be authorized by the law, such as the COMELEC and Ombudsman. Rule 113 is arrest. Section 1 of this rule, arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. It shall be the duty of the officer executing the warrant of arrest, the accused, and two officer executing the warrant of arrest to accuse and to deliver him to the nearest police station or jail without unnecessary delay. In Section 4, Rule 113, the warrant to be executed within 10 days from its receipt within the 10 days after the expiration of the period. Section 5, Rule of 113, a peace officer or private person allows to arrest a person without a warrant when 1. Caught in the act or in flagrante delicto. 2. Personal knowledge or hot pursuit. 3. Escape prisoner. Section 11. Police officer must identify themselves and announce their purpose before using force to enter, apply the first break, and announce doctrine. Rule 114 is bail. According to Section 1 of this rule, bail is a security given for the release of a person in custody of the law, furnished by a ombudsman to guarantee his appearance before any court. Section 2 of this rule, 1 rule, all person having an offense can avail bail except those charged with the offenses punishable by the reclusion perpetua, death penalty, and life imprisonment. Section 4 of this rule 14. Bail is a matter of a right when the before and after conviction by the municipal circuit, metropolitan trial court, and municipal circuit trial court. Rule 115. The rights of the accused. The accused in criminal prosecution have several rights including 1. Presumption of innocence. 2. Right to be informed of the nature and cause of accusations. 3. Right to be present and defend themselves. 4. Right to waive their presence at the trial unless specifically. Rule 116. Arraignment and play. According to the paragraph A, section 1 of this rule, The accused must be arraigned before the court where the complaint or information was filed or designed for trial. Paragraph B. State that accused be present at arraignment and must personally enter his plea. According to the paragraph C of section 1 of this rule, if the accused refuse to be played, a plea of not guilty shall be entered for him. Paragraph D. When the accused pleads guilty but present exculpatory evidence, his plea shall be deemed withdrawn and the plea not guilty shall be entered for him. Rule 17, 117. Is the motion to quash or the request for dismissal, section 1 of this rule. The accused may move the quash to the information or complaint anytime before entering his plea. Rule 118. Pre-trial. According to the section 1 of this rule, pre-trial is mandatory in criminal cases. It is conducted to avoid surprise. Section 2 stipulated that the agreement or admission made or entered during the pre-trial offense shall be 1. Is reduced in writing. Rule 119. Trial. According to the section 1 of this rule, the time to prepare the trial is after a plea of not guilty is entered. The accused shall have 15 days to prepare for a trial. The trial shall commence with 30 days from the receipt of the trial order. Section 3. The period of delay shall be excluded in computing the time within when delay resulting from other proceedings concerning the accused, delay resulting from the mental incompetence or physical liability of the accused to stand trial, and if the information is dismissed upon motion of the prosecution. Section 11. The order trial which first the prosecution shall present evidence to prove the charge. Section 17. Is the discharge of the accused to be state witness happens when there no stronger directly evidence. Section 23. The demurrer of the evidence it was after the prosecution raised its consists the court may dismiss the action on the ground of the insufficiency of evidence. Rule 120. Judgment. According to the section 1 of this rule, judgment is the adjudication by the court that the accused is guilty or not guilty of the offense, charge, and the imposition on him of the proper penalty and the proper penalty and civil liability. Rule 121. The new trial or reconsideration. According to the section 1 of this rule, the time for new trial or reconsideration is any time before a judgment of conviction becomes final. Section 2 is the grounds for a new trial. First is the error of the law. Rule 122 is the appeal. According to the section 1 of this rule, any party may appeal from a judgment or final order unless the accused will be peace in double jeopardy. Section 2 is where the appeal win from a first level court or MTC appeal on RTC. Rule 123 is the procedure in the court in the municipal trial court. Rule 124, the procedure in the court of appeal. Rule 125, the procedure in the Supreme Court. Rule 126, the cease and seizures. Section 1, define the search warrant as on order and writing in the name of the people of the Philippines, signed by the judge and direct to the peace officer commanding him to search for a personal property described therein, bring it before the court. Section 3 are subject of the offense in this settlement property and used for the intended to be used as the means of committing an offense. Section 7. A search warrant shall not issue except upon real probable cause and conviction with one specific offense to be determined personally by the judge. It should be found in Section 4 of Rule 126. Section 7. Police officer must identify themselves and announce their purpose before using force to the enter. Thank you, sir. This is oral revision, and Happy Merry Christmas and advance Happy New Year.